globe. And I know
Uganda at various meetings of the World Intellectual Property Organization, where he is immediate vice chair of the Paris Union Executive Committee. Agaba is also a registrar of intellectual property rights, and in this role, he examines and registers trademarks, patents, industrial designs, and copyrights. He has audited collective management organizations. He also adjudicates in contentious matters in prosecution of intellectual property rights, and is responsible for ensuring the quality of the intellectual property rights granted. He is an avid promoter of intellectual property as a tool for development and participates in various sensitization and awareness exercises internationally and nationally. It is my pleasure to introduce Gilbert Agaba as moderator for this session. Gilbert, you're very welcome.
Thank you, Navindi, for that very generous introduction. I don't know whether I feel I don't match it, but thank you very much. Ladies and gentlemen, good morning, good afternoon, and good evening from wherever you are in the world. It's my pleasure to join you today to discuss this topic, intellectual property and public sector information. Like you heard, I think, differing from the topics that we've been discussing since yesterday, this one focuses on the aspects of intellectual property, which some of your offices might be handling and some may not be handling. But today we're experiencing, for those who are not handling IP, we're experiencing something new. And for those who are handling IP, I hope you will enjoy this discussion. On this panel, I'm joined by three eminent people in the IP world. First, I have Muriel van Eschhout. I hope I pronounced the name well. She's a professor of information law at the Institute for Information Law, University of Amsterdam in Netherlands. And she's the director of Amsterdam Graduate School of Law. You're welcome, Muriel. Also, we have Mr. Paulo Lanteri, is a lawyer specializing in intellectual property law and a member of the Spanish and Italian bar associations. Paulo works in the copyright law division of the World Intellectual Property Organization and is part of the restricted team of lawyers dealing with all the copyright substantive matters within WIPO, ranging from legislative and policy advice to member states, to managing a number of projects in areas of intersection between copyright law and new technologies such as user-generated content, artificial intelligence, access to knowledge initiatives, and emerging licensing schemes, including public sector information and open science, which is the subject of our discussion today. And finally on the panel, we are joined by Mr. John Kabari. John Kabari is a patent examiner with over 25 years experience. He's currently the executive in charge of operations at the African Regional Intellectual Property Organization. We'll have an opportunity to tell us more about his organization, and he's very passionate about intellectual property, and he will be making meaningful contributions to our discussions today. Please, if you see me looking down, it's not that I can't see you. I'm looking at my face here in the camera, so I have to look down, but I'm with you. The session, we will start with a presentation from Professor Muriel, and thereafter we'll have a panel discussion. And Professor Muriel will give us a background of this topic, which might be new to some of you, but also to share opportunities in terms of IP and public sector information. So allow me, without further ado, to welcome Professor Muriel to make her presentation. Thank you.
Thank you. So it's an honor. I'm very glad to be here, and there's a definite advantage to doing this online. But the one big disadvantage is that I cannot actually see the audience and pick up signals where you might want me to expand a bit or explain a bit more. on certain terms or concepts, I will explain. So please feel free to react in the chat, and then the moderator will relay the questions to me. And to start, maybe to say that I am familiar with problems around or challenges around corporate registered data in the Netherlands and more broadly in the EU. But I'm not from the field, and you might notice in my terminology that I use terms like business registers, corporate registers, companies registers interchangeably. That has no particular meaning when I do this. So just so you know. So I think the question is maybe first slide. What is the deal with corporate registers? What are the broader developments around access to public sector information and intellectual property? And then first, let me tell you a story.
Sorry
yes.
to interrupt. Can you put up the slides? We can't see the slides.
Ah, okay. I thought the moderator was to.
Okay,
yeah,
okay. Yeah,
all
right. Thank you.
That's the first one. The first slide has very little information. Okay, so what I was saying is, so what is the deal with corporate registers and the broader developments around access to public sector information and the link to intellectual property, and particularly copyright and database rights? So let me tell you a story from my home country, the Netherlands. This summer, a lower court ordered the Dutch Companies Register to refrain from imposing its new terms and conditions for the resale of data. And this court case is just one in an episode in a very long saga. Actually, it's been going on for years. Essentially, the conflict is around this. The corporate register has a legally defined task to maintain a public register. And as you know much better than me, that can contain a range of information from financial accounts, annual reports, information on board members, registered addresses, and so on. And you also know how much work it is and how much investment it takes to organize and run such a register. Now, there's always been a lively trade in the Netherlands as elsewhere in company data for credit rating purposes, for marketing purposes, all kinds of different things. The Companies Register, run by a public sector body, a kind of executive agency, the Chambers of Commerce, essentially has to recover its costs. And it gets most of its funding from government users through registration fees of companies and entities that need to be registered, but also from commercial users, information service providers. Now, if it would not be able to impose conditions allowing it to control the downstream use, copying and reuse of data, it would be less able to recoup its costs. And that is a reason why, through its terms and conditions, it seeks to limit what downstream uses can be made of data.
Professor?
Yes?
Sorry to interrupt again. Your sound is a bit choppy. Is there something you can do about it?
I can turn up the volume a bit. Sorry, is does this improve?
Yeah.
Yeah.
Yes. That's better. Thank you.
Okay, so Companies Register basically works under a cost recovery model, and the companies that get data from the corporate registers have an interest in being able to repurpose it and use it freely and make new products. So this is what the conflict is about. The connection to the wider regulatory framework around access and reuse of public sector information and the role of intellectual property rights comes to the fore here. And this has to do with the legal reasoning that goes on in these cases. The Companies Register say we have exclusive rights, we own data or the data sets that are at stake, and we can impose conditions for the reuse, and those conditions are in conformity with the existing Dutch law on reuse, and the Dutch law on reuse is an implementation of European rules in that regard. The information service providers say they've joined forces, set up an association to manage their interests vis-a-vis the company's register. They say, no, there is no such thing as intellectual property rights in that type of data, and the terms and conditions you want to impose contravene the rules of this reuse framework in the EU. And that reuse framework also applies to company registers. And that is a point that everybody agrees on. I mean, it's very clear from the law that the Open Data and Reuse of Public Sector Information Directive, that is the main instrument in the EU, applies to companies' registers as well as to a lot of other public sector information. What they don't agree on is how much leeway the companies' registers have under that law to set terms and conditions. Now, the president of the court, this was a fast procedure for injunctive relief, so it wasn't a ruling on really the merits of the case. The president of the court said, well, it's likely that the court who has to rule on the merits will say that there is indeed an intellectual property right or a database right in the company register, and that the company chambers of commerce own this. And it could also well be that the company's register, in the particular terms and conditions it wants to impose, is acting, contravenes the Dutch law on reuse of public sector information. And the outcome was that for now, public sector, can I have the previous slides, please? Okay. Thank you. So the question, I think I think somebody put the slides on sort of automatic. Yes, stay with this slide, please. So the court basically said, chambers of commerce, companies register, you cannot implement these new changes until there has been a proper ruling by another court. So this was a small win for the information service providers. And as I said, I do not know much about company registers throughout the world, but I am guessing here that you recognized at least some of the tensions. You know, there are different public and private interests in accessing using these data and also on limiting access to data. So how do you balance them? And what are the implications of having a certain funding model for a business register? Obviously, that plays a large role in the Netherlands, and I know it also does in the UK and in other countries. Because when it comes to funding, there is a spectrum of saying we'll just fully fund the register from taxation, even if that means we have to either raise taxes or we have less money for roads or health or education. And on the other side of the spectrum, you can say, we'll just make it a user pays system where everybody who directly benefits from the data bears the costs, and there are no sort of general costs for the taxpayer. And there's a lot of models in between. And the thing is, so in the Netherlands, there's partly lump sum payments, and there's partly registration fees, and there's the money that you pay to actually make use of the data. And there is a direct link with intellectual property rights, both in the Netherlands and the EU, and I imagine also in other countries, because intellectual property rights can be a really important or a crucial tool to sustain a certain funding model. And at this point, you might ask, is it not enough to have contractual terms and conditions? Do you need intellectual property rights? And the short answer is yes, they come in very handy, because a key characteristic of sort of terms and conditions is that only the parties that you enter into a contract with have to abide by them. So if you want to control once information or data has like escaped into the market, if you want to control its further use, it's really difficult to do so on the basis of contractual relationships you have with your main clients, because you will not have these contractual relationships with the reusers you want to address. And intellectual property rights, because they are exclusive rights that you can sort of use against anybody, are a good instrument then make sure that there's no sort of leakage of data, I would call it. So this is why intellectual property, copyright and database matter. Then, of course, you can have a question about are there intellectual property rights in company data to begin with? And I think we can spend the rest of the day arguing exactly what type of information that is in these corporate registers is subject to intellectual property rights and to which rights. And we particularly talk about copyrights and quasi-copyrights like the EU protection for databases. But by and large, at least at the international level, it's accepted that databases as such can be the subject of copyright, even though the specific contents and factual data individual may not be. And for the purposes of this presentation, I just work on the assumption that there, at least in some cases, are some aspects of data in companies' registers that are indeed protected through intellectual property. And if we focus on copyright, for those of you who are not familiar with copyright, you will have associations, I think, in terms of the media, the entertainment and media you use, and films you watch, and software you use, and perhaps be aware that there is copyright in these types of creations. So generally, it's intellectual creations in the literary, artistic, and science field, which is a really broad concept, and it can include all kinds of business type applications. And the rights you get are rights to control the reproduction and the copying and the adaptation and the distribution and making available of the work and copies of the work. So they're quite far-reaching rights. In addition, the EU protects databases through a separate right that's based on whether there's a substantial investment in the creation of a database, and you get your own separate intellectual property right. And in terms of its scope, what rights it gives you is very similar to the type of rights that copyright gives you. So we can say corporate registers can be subject to copyright and similar intellectual property rights, or documents that companies have to provide to companies' registers may be protected. And we can discuss about the context about whether public registers and the contents should be the subject of exclusive rights in the first place. You can make an argument saying, okay, particularly if these are publicly funded and there's a public interest, if you look at the rationale for having copyright protection or for having database protection, it doesn't really apply to companies' registers, or it shouldn't apply. But that's more of a political discussion about how far you want protection to reach, and maybe we can pick this up in the panel. So for the wider picture, let me share a few trends. One is that the public sector keeps growing, and so does the character and volume of information. Previous slide, please. So that's the first trend, because the public sector and societies develop and governments become bigger, take on more responsibilities compared to maybe 19th century visions of government, which were very limited. And that goes hand in hand with enormous amounts of information collection, not just laws and legal decisions, but in mapping, health information, all kind of data on the environment, transport, education, you name it. And of course, company registers are also in there and have been actually for a long time. Second trend is that we see really a development to more rights to information, rights to actually, for citizens and companies to get access to certain information and data. And part of these laws also stimulate governments to make data proactively available, particularly in the executive branch, but also with respect to legal information. So that's another trend we see. There's more information out there or in there in government agencies, and there's more rules around making this available. And not just for transparency purposes, which is sort of the traditional rationale for having access to information rights, but also because you want to promote the reuse of information for societal and commercial purposes. And there, of course, it's then really important to have clarity on what the terms of use are for this information. Fourth trend, it's not really a trend, but worth mentioning, it's more of an issue, is that it's still quite uncertain if you take a bird's eye view from the international perspective, what the copyright status of public sector information is precisely. So this is something I already touched upon, and we'll discuss it a bit more later. We have a large number of international treaties with many countries signed up, also in the field of copyright and related rights, but there's only one, like the mother treaty of them all. It's called the Berne Convention, that has a clause which says member states or countries are free to choose whether how they want to treat official texts of the government. So there's a freedom for countries to decide whether they want to protect it or not. And there is also agreement with respect to databases. And databases as such can be subject to copyright, but there are no specific rules on is it also true for databases run by the public sector. In many countries, the distinction is not made between the public and private sector. So basically, in the international legislative framework, there's little for countries to go on to decide on what their policies should be, and there's a lot of diversity you see nationally in this field. So just to recap what I've said so far, there are a number of trends towards opening up public sector information for a multitude of uses. This can also, this pressure is also on company register data. And that's one hand, it's very connected to accountability and transparency improvement, but also on using company data to help the economy grow, making them innovative services and products. And what we've seen is that actually the copyright status of public sector information has a broad category, but also the status of corporate registers is unclear from the intellectual property perspective. I have a few slides to visualize just how these trends have developed over the years. So next slide, please. This is one that shows how access to information rights and laws have spread across the globe. Don't pay particularly attention to the coloring. It's just a map to give you an idea. The color coding is due to a ranking that civil society groups have made, looking at 60+ indicators for what makes good access regimes and legal frameworks. Like what information is available, can you enforce as a citizen or a company these rights you have. What I just want to show here is how few gray countries there are, right? So most countries have a color, which means they have some form of recognizable access to information framework. And this map would have looked really different 25 years ago, let alone 20 years ago. Also in the international field, the Organization of American States, African Commission on Human and People's Rights, and so on, all created model laws for countries to follow. And of course, you will know better than me that business registers, if you know the history of the sector you work in, are one of the oldest type of registries, together with land registries and population registries, and countries have had them for 100 years. But the wider laws around providing access, public access to information are somewhat younger than the specific laws you might have regulating access to business registers. Next slide, please. So closely connected to the rise of access laws are so-called open government initiatives. 10 years ago, the Global Open Government Partnership was formed. It's a joint initiative of national governments and local governments and a lot of civil society organizations. And their main ambition is to increase transparency and access to information on government and information from governments and public sector at large. One of the things it aims to do is ensure that more high value information, and that would include corporate registers, is made available proactively by all its participants. And the countries actually join the initiative. They then develop national action plans, which say what concrete steps are we going to take to make sure access improves. And that's monitored through an independent review mechanism. So it has some teeth. And it's grown to nearly 80 states now. And one of the things on its agenda is how to improve opening up corporate registers, particularly beneficial ownership data. And particularly to help fight corruption and get a better view of extractive industries and so on. Next slide, please. So if we look at the corporate beneficial ownership registers, this is another civil society organization that has tried to map what the commitments are of countries across the globe to make data on beneficial ownership available, and the darker blue are the stronger commitments and the light blue are the lighter commitments. And you can see there's a lot of activity going on there. At this point, I think it's good to note that saying a register is public or must be public doesn't mean that everybody gets access to the full content for whatever purpose they like. There is, however, I think you can see a trend when it comes to public sector information to say, okay, even though we must protect data protection and privacy and particularly commercial interests of the private sector, for instance, we must have maximum transparency, and the default should be that data is made open unless there are strong countervailing interests not to do so. And that's the kind of pressure that's also on corporate registers. And this ties in with what the trend towards more open data, and usually the trend is towards more open public sector data. And for those of you who are not familiar with the concept, in sort of the ideal of open data, there are two dimensions to openness. One is technically open, and data is electronic, machine readable, supplied in an open and not a proprietary format, accompanied by metadata, so that you know the quality of data you're getting, and all these sort of other dimensions that make data technically open. And then there's the legal dimension of openness. And that basically, in an ideal situation, says anyone can use data, anyone has access and can use data for whatever purposes. And at most, there might be an obligation to attribute the source where you get the data from. The consequence of this concept of open data is, if you were to apply it diligently, is that basically you cannot really exercise any copyrights or intellectual property rights, because that would run counter to the idea of making data really open. Next slide, please. Just a reminder, because I can imagine if you're not familiar with intellectual property, you will not have remembered what we discussed earlier. So when it comes to intellectual property, there are generally no specific rules on treating public sector information on corporate registers in a certain way. There are, under international law and also in national laws, a recognition of that there can be normal copyright in databases, so that would also apply to company register data. And perhaps of interest to know is that there has been in the past a lot of discussion at the WIPO level, the World Intellectual Property Organization, about should we have a special right for databases, the EU style database right, but that discussion I think is pretty, I don't know whether it's really shelved, but it's not very alive today, but I'm sure Paolo Lanteri can tell us more about that. Okay, so I think the takeaway from this is it really depends on the national situation whether there are exclusive rights to be reckoned with, and it also depends on where you are in the world, both regionally and locally, how strong the policies are towards opening up more register data. Next slide, please.
Professor, let me interrupt a little bit here. I know you said you want Paulo to say some additional matters. I want to also give him time. So I don't know whether you can conclude in the next 5-10 minutes, and then
Yeah,
we can
sure.
have.
Yes,
All right,
5 minutes is 5 minutes.
All right.
Okay. So if we look at the next slide, I've listed some, with question marks, some roles that intellectual property rights, and particularly copyright or database type rights, can play in corporate registers and in the management of corporate registers. We've already seen it can serve as an instrument to control downstream uses where contracts aren't enough. And it's therefore also an instrument that can help secure payment for use and recover costs. It's also often argued that intellectual property is really necessary for the public registers to be able to safeguard the data integrity and reliability of data, because it gives them a means to address sort of like rogue or companies that supply faulty or very old data, these kind of things. But intellectual property is, of course, also an instrument to protect third-party interests. And businesses might even own copyright in, for instance, annual reports that they have to submit. So it's quite a complex picture, and you might think of more reasons why you think intellectual property comes in handy or is not a good idea for registers. Few words then on why in the EU the situation for company registers has become even more complex. So next and final slide, please. So we have in the EU since 2003 a piece of law, a directive that member states have to implement in their national laws, which was initially called the Directive on Reuse of Public Sector Information. It's been revised a couple of times. Latest revision is from 2019, and now it's called the Open Data Directive. And its main principles are that for data or for government information held by public sector bodies that is public under national law, so there is a form of access to it. The idea is that this must be made available for commercial and non-commercial reuse to the maximum extent, using either no terms and conditions or standardized terms and conditions. Not charging anything is the main rule. That the data are made technically open as far as possible. We discussed before what the technically open aspects are of open data. And in this 2019 version, it even have an explicit provision saying you should not exercise these specific database rights for public sector information if that contravenes the obligations under the Open Data Directive. So this is where, in the example I mentioned, started my talk with in the Netherlands, where a lot of the conflict is about, okay, how far do these obligations from the Public Sector Information Directive go, and what is the room that companies registers have actually to use intellectual property rights and copyrights and database rights. The answer to this can take a very long time. Ultimately, it will be the Court of Justice of the European Union who has to interpret this piece of legislation. So we'll see what comes out. But to conclude, I would say, I think that in light of the international movement towards more transparency for all types of public sector information, including corporate register data, and this open data discussion that's gaining traction, corporate registers and their audiences and customers have to deal with this larger playing field where the rules of the game are set for the broader landscape of public sector data and are not necessarily tailored for what works well historically in the field of corporate registers. That would be an additional challenge for you all. And I guess also a great reason to keep having these kind of conferences so you can have exchanges on this topic. Thank you.
Thank you, Professor, for that elaborate presentation. I know it has taken more time than planned, but it was necessary because most of us as corporate registrars, we deal with this information as a matter of legal obligation. So understanding issues of access and reuse is critical for the next level of involvement. When I entered here, Justine was talking about registries as services, and going that direction, definitely the interface or the interaction between IP and these registries will be critical to understand. Those of you who have questions, kindly put them in the chat and we'll have an opportunity at the end to go through them. But now allow me to invite my discussants. First, let me start with you, Paolo from the World Intellectual Property Organization. Please tell us about WIPO and your experiences with public sector information.
Thank you very much, Mr. Gilbert, Mr. Akava, and I would like to thank, of course, the Corporate Register Forums and the Uganda Registration Service Bureau for this invitation. WIPO is thrilled to be invited to contribute to this discussion with an audience that is absolutely new to us. Let me start with the conclusion based on what Mireille just said to us. I think no matter what is going to be your public policy in terms of giving or not giving access and allowing or not allowing reuse of the data you produce and you manage, intellectual property deserves to be taken into account to have meaningful and effective policy in practice implemented. And next, after the conclusion, I'd like to tell you where we are coming from and who am I. I'm representing the World Intellectual Property Organization, which is a UN agency that works with 193 member states. All of you represented here are member. And our mission is to develop a balanced and effective intellectual property system for the benefit of all around the world. So you may well ask yourself what we're doing here, because beyond the fact that we run registries ourselves and the fact that being an international organization, we are considered to be public sector as WIPO ourselves, perhaps the link to the management of PSI in general is not that intuitive. In fact, the public policy debate about public sector information at our level, and I'm coming to the point that are relevant to you, is in a way much broader, because when we discuss public sector information, we discuss the vast array of material generated somehow by any public body in all sorts of fields: taxation, meteorological information, geography, health, laws, demography, and so on. And that kind of material can be reports, can be websites, can be data sets, can be databases. Most of them, in a way or another, are protected by intellectual property, as we have already seen. So it's much broader, and we are not here to say that registries are exactly the same of any other public sector body. We understand the differences, and we understand registries might have a unique purpose to serve, and also unique legal recognition in each country. But the broad debate remains the same, which is what do we do with the information that is generated with public money, and how do we allow the best reuse of that wealth of information that can improve not only transparency but also economic development. At the same time, at WIPO, we always looked at this matter from a very narrow perspective, which is how the intellectual property system has an impact on how this information is accessible and reused. This is far from saying that IP is the most important area of law in this discussion, we recognize certainly that access of information, freedom of information, transparency, data protection, but also private data protection, confidentiality, national security, competition are all very important considerations that governments have to take into account when they shape their policies in terms of public sector information. However, there is a difference between access and the possibility of reuse this information. And when it comes to reusability of the information created by the public sector, intellectual property becomes an essential element you need to deal with, because intellectual property would tell a citizen whether or not they can reuse something they find on your websites or your databases. And this is where I'm remaking the point that unless something is done, intellectual property will apply by default, and therefore it needs to be included in the homework of public bodies. We have looked at these issues through the years. It's quite a new debate here at WIPO, perhaps as 10 years. It's 10 years old. And in those 10 years, we developed several studies, several activities. And I think for the purpose of today, I can highlight a couple of issues / trends that have been largely covered by Mireille, but it doesn't harm, I think, to restate here. And first is that the awareness of the importance of public sector information as the wealth of information generated by public bodies is increased and is growing around the world. And there is, I think, consensus in seeing merit and benefits in allowing, whenever it's possible, access and reuse of that information. That's something perhaps not all people running a corporate register would agree on, but it's something that the general public level, it's a clear trend. And we have seen that there is a growing number of countries that are joining the open government policies and are trying to give more access to that, but very few of those countries and those policies are actually entering into the details of IP rules applicable to PSI. We have seen that countries can exempt from protection certain public sector information, official acts, but that is very partial part of the public sector information. And so ultimately a proactive, conscious approach is needed. No action in this field means sometimes missed opportunity, in the sense that if you don't clarify, for instance, on the terms of use of your website, what the citizen can do with the information available, by default, copyright would apply, which means that citizen cannot reuse that information unless a law says that, unless your terms of use says that, or unless you decide to implement a specific licensing condition. So here's where I'm saying there is a need to look at those things carefully. And if the answer is you don't want to give a possibility of reuse, well, you can take steps in that direction. But if you want to give possibility of reuse of the information, if you don't do anything, your policy will not be effective. It cannot be implemented in practice. So if you want to give access, it's often the case you need to gather this information, offer access to a repository, or implement clear terms of use and clear licensing conditions. And even when there is no central public policy in your at the country level or in the sector level, individual institutions can still do meaningful, can still take meaningful steps. And here I can give the example of WIPO, the organization I work with. The World Intellectual Property Organization is within the UN family, but we have never received any instruction or guidance on what we should do with our information. So voluntarily in 2016, we stepped in what we called open access policy, whereby anything you find on our website, all the studies, all the material can be freely reused for all purposes, including commercial purposes, with the only condition of recognizing the origin of it, the attribution, the source of the information. Unless otherwise stated, there are exceptions. And those exceptions are typically the cases where we offer access to material that is not owned by us. We don't own the intellectual property. We don't control the intellectual property on third parties' content. Therefore, we are not in a position of sub-licensing that content. So with that exception, I think that point also answers one of the questions in the chat, which is very important. It says from Peter Benson, saying a model where government enacts laws requiring that businesses provide data that the government then claims as its copyright and resells appears to be problematic. Yes, of course, data, first of all, raw data are not protectable by intellectual property and copyright. What Mireille was trying to explain, the structure of the data, the database on which major investment has been put to that creation, that structure is protectable by copyright if original, but the data themselves are not protected. So those are not cases where the government claims copyright on third parties' data. I think it's we are lawyers. It's hard to be easy to be understood in these cases, but what we are talking about here is about giving access and allowing reuse of what can be protected by copyright, and raw data cannot be protected. So the models where the government charge for accessing information are not based on a copyright model in the sense of data provided by corporations will not be claimed by the government as their copyright. But I'm sure Mireille can tell more. And I think with that, I would end my my short intervention. And what I would remark is that it would be very interesting for us to understand what is your practice in your registries around the world. What are you allowing third parties to do with the information you manage?
Thank you, Paolo, although you should be the one answering questions, but I know the participants have taken note of your question. And I think what is critical is how we understand the information that we hold as public sector bodies. Like Benson is asking, this is public, I have a public interest. Why am I creating some constraints on accessing it and reusing it? And I think you correctly elaborated that IP comes in the moment you create a new database out of your registry, and then this information that you have collected has to be reused by a third party for any purpose, including economic purpose. And thank you for sharing WIPO's experience in that regard, and we believe that members have taken note. Now allow me to invite Mr. Kabare from the African Regional Intellectual Property Organization. And also, Kabare, could you briefly share with us the experience of ARIPO or its member states in respect of public sector information? Unmute your microphone.
Thank you, Mr. Rabba. Good morning, good evening to colleagues, depending on where you are. First, let me take this opportunity to thank the organizers for inviting ARIPO to participate in this corporate registry forum. It's our first participation in such an event. Before I just talk about the experience, let me point out that ARIPO is a regional intellectual property organization established way back in 1976. We have 21 member states spread across East, West, Central, and Southern Africa. And we have basically a mandate on intellectual property that is both industrial property and copyright and related rights. To fulfill our mandate, we have a number of legal frameworks that we use to implement our mandate, and this includes the Harare Protocol for patents and industrial designs. We have a protocol for trademarks, which we call the Baju Protocol for marks. We have a protocol for traditional knowledge and expressions of folklore, which we call Sokomod Protocol, protocol on plant variety, Arusha Protocol, and a recent protocol that was signed about 2 months ago in Kampala, Uganda, which we are calling Kampala Protocol for voluntary registration of copyrights. Over and above our mandate in intellectual property, we do also have offer training and capacity building in the area of intellectual property, and we also do exchange or disseminate IP IP information. Having said that, I would want to indicate here that Alipo, our engagement with the topic we are discussing today, public sector information, is not a topic that we have been discussing much about, but we look at it from another point of view. We look at it from the point of view of intellectual property associated with public sector generated information. And we are aware that IP is routinely generated in the course of government business and includes both written material, websites, software, infrastructure, design, and various types of research and analysis. From this point of view, we are also aware that the issue of access and reuse of public sector generated information would traditionally bring questions relating to intellectual property issues, And for that matter, we look at a number of challenges associated with public sector information and also opportunities that would do also arise. For example, a number of the challenges that we have been able to identify relating to public sector information, IP related to public sector information, is lack or limited awareness about IP that is contained in public sector generated information. Secondly, there is also the failure by many government agencies to identify the IP they generated. They are doing work, they generate information, but they fail to identify IP that they have generated. Also, in many instances, there is premature disclosure of intellectual property that has been generated, failure to protect intellectual property, failure to manage intellectual property, that is record keeping, protection, renewal, maintenance, enforcement, such issues, or rather also limited or no commercialization of IP if public, where public interest wouldn't be where public interest, where it would be more important to commercialize rather than having it as public interest. Of course, there are also issues, challenges associated with lack of policy surrounding or allowed IP associated with open access. So later on, we can discuss about the opportunities that would be available for such issues. I will stop there and maybe hand over back to the moderator.
Thank you, Kabali, and you've stated at the very end about the challenges that public sector bodies will face in terms of IP and public sector information, and it is relevant to all of us. Now, going back to the professor, in about 2013 or 14, the OECD estimated that public sector information will contribute about $500 billion to the economies of OECD countries. Clearly, there is an opportunity that has to be harnessed. And we've heard from Paulo that whereas access might be affected by other different types of laws, intellectual property impacts reuse in terms of how this information that is generated by public sector bodies is reused. In your experience, what are the challenges or issues that we need to bear in mind in terms of the interface between reuse and intellectual property? And what are the constraints that also you envisage when registries start considering their policy on PSI?
Thank you for that. That's an excellent question. I think, I mean, the developments in the EU show that there's an acute awareness of what the value is of allowing reuse of public sector information, including reuse of corporate registers data. And basically, I think one of the challenges, particularly for corporate registers, also is the funding. That if you really want to do allowing reuse well, then basically you have to have a model where it's the taxpayers that actually fund the running of the registry and the creation of the registry, and then the further use would basically be free or only against the cost of dissemination of information. That's the regime we have in the EU now generally, but for those corporate registers that are under a national obligation to recover their costs, there's kind of an exceptional status in the Open Data Directive. But more largely, I think a lot of it comes around to funding models, and also it can really help to have clarity, clear rules on what the intellectual property status of public sector information is. Now, we've heard that these are really broad categories, so it's not that easy to say, okay, we'll just not protect any public sector information, because the source of that information might be the private sector and citizens who, routinely have to supply lots of information to the government for all kinds of different purposes. So it's not that simple to differentiate, but at least starting to address the issue that it really doesn't make sense to say across the board we will treat all information held by public sector bodies at the same level under the law as we would information held by private sector entities. That would already make a difference. To really have more of a discussion on that. It's a bit of a blind spot, I think, in many countries.
Thank you, Professor, for that. I think members are taking note of your guidance, the challenges that they might come across, and how we can redress them. The question I want to point to Paulo. Kaba also mentioned about the challenges that countries might face in terms of PSI reuse. Paulo, what would be your advice on mitigating these challenges? And maybe before you look at those mitigating these changes, what opportunities are there in PSI for specifically corporate registers, and how do they mitigate these challenges that Kaba has mentioned and that the professor has also highlighted on?
I think I need to try to be simple here. In my personal experience, in my opinion, the main challenge to make to create a healthy environment of PSI to be reused is awareness. As mentioned, there are many important public policy considerations when we talk about giving access to public sector information, and copyright, as much as we in this panel like it a lot, is not high in the minds of policymakers, is not high in the mind of many decision makers in very key places. So one of the key challenges we have seen is that even when you find a clear willingness to share certain amount, a part of that big body of public sector information, and you understand the enormous societal and economic benefit in that resharing, sometimes the people taking this decision are not fully aware that IP needs to be taken into account and treated, and should be upfront said what will happen to the intellectual property attached to this information. The panorama we have is complete lack of harmonization at the basic level. We do have, however, a growing number of countries that proactively create repositories and proactively decide to license that information. However, if we talk to, I mean, in a global scale, they are still a minority. So the main challenge is in my view, the part of the administration dealing with IP to make the other part of the administration aware of these challenges. And also a debate needs to be open. That's the first step. What the government is willing to share with the citizen. And it's interesting to see the history at the European level. We came a bit late compared to, for instance, to the US. And I think Mireille must have mentioned, but the benefit for society are huge, because if you don't take a proactive approach, we ended up in Europe, for instance, accessing services that were telling an Italian citizen how to reach what was the fastest route to the hospital. And that company was based in the US because they already started that business in the past. Or if you want to see whether here in Geneva is raining or not, you may end up consulting a company that is not based in this country. And just example from the most varied area of the economy where the benefit for society is enormous. And so it's a central government level policy that should then come down to the registries and say, look, I know you feel strongly about not sharing all the information, but down the line, this information sharing would bring enormous societal and economic benefit. So many challenges ahead.
Thank you, Paolo. And I think your emphasis of taking proactive steps, because all of us administer this PSI, and from either our history or legal provisions, we either hold this information or we release when first cajoled or pushed, and then we are not seeing the opportunity that's there. So John, you said you talk about opportunities. What are those proactive steps that these registries should take to be able to drive value for society and for their economies through this PSI? What are those proactive steps that they need to take? I know some are already sharing this information, but they need to see the opportunity there and what steps they need to take into account as they do that.
Thank you, Mr. Moderator. I'll first begin by saying, associating myself with what was said by the delegate from WIPO about awareness raising, that awareness raising is key. Is key opportunity that we can be able to take advantage of and be able to raise awareness firstly with the management of a government agency or those people that are responsible for running the agencies, to try and raise awareness about the IP that is probably generated through public sector information. Secondly, and I think a very important point for me, is the establishing of an IP management policy within these government agencies. And the policy should be able to address a lot of issues that should include, the policy should provide a framework for the use of public sector generated information, for the generation, acquisition and management of intellectual property that has been generated. And the policy should contain a number of elements, including, for example, ownership of IP, who should own the IP, identification of IP. I mentioned that one of the challenges that's associated with public sector generated information is lack or limited identification of IP. So in this IP management policy, there should be an element of how these assets can be identified. There should be an element of how to register IP or to review the IP that has already been registered. There should be the issue of training. Contract should also be the issue of contract. If a government agency is entering a contract with another agency, the contract, what should be contained in the contract. The issue of open access should be addressed. Use within government or sharing this information with the other government agencies. I mentioned about the issue of commercialization. If need be, then this kind of aspect should be contained in the policy. There should be also incentives addressed, staff incentives in case they generate IP when they are during course of their work, when they generate public sector incentives. So those two main areas, awareness and IP management policy, for me would be key opportunities that should be developed by, that be seen as an opportunity. Thank you.
Thank you, Kawali. That was really very clear. And I think policy and awareness is critical. And one of the objectives of today was to already bring this topic to the fore, to ensure that we know that these issues touch on what we do, whether we are registering companies or whatever we're involved in. As long as we're a public sector body, these issues will arise and they will find us. And it's important that we are ahead of them. I've not seen any questions, but if there is any questions, specifically if there's someone who wants to share briefly on the experience with PSI from the audience, we'll give them the floor briefly, please. And if there are any other questions, you can also raise your hand or type it in the chat. We have 5 minutes. Questions, comments? It seems here in Uganda it's lunch hour, so people are preparing for lunch. I don't know whether it's the case where you are, but either the topic is too new or you at least know what you don't know and you start from there to learn about the topic. If that's the case, the panelists are available through the website. Please chat with them, contact them if you need their support, engage them to see if they can help you develop policies and also deal with issues of awareness, but also deal with the other aspects outside reuse, specifically policies that control access. And also you can contact them on even to facilitate you in that journey. I would like to thank the organizers. It's a pleasure to share this topic, and we believe that has added value to you, and we look forward to next year, maybe we will have a different discussion about this issue. But thank you very much, and allow me to close this discussion right now and hand over back to Navind for the next agenda. Thank you. And thanks for our facilitators, sorry, but thank you very much for sparing the time. Paolo from WIPO, personal regards to the Director General. Muriel, it was a pleasure to have you. And Kawali, thank you for sharing the experiences of RIPO. Thank you for sparing the time. We will take this offline and discuss other ways you can support the participants. Thank you.
Thank you. Bye.
Bye.
Okay, thank you very much, Gilbert and the other panelists. All the attendees as well, please, you can now log into the next session, which will be on the authoritative legal entity identifier and ISO. For now, you log out of this and then log back into the next session. Thank you again for joining us. Looking forward to seeing you in the next session. Good afternoon.